Welcome to today's news update. We begin with a major development. After 35 years behind bars, the case of Clive Freeman has now been referred back to the Court of Appeal by the Criminal Cases Review Commission. A moment that could prove pivotal in his long fight for justice. Also in the headlines once again is Michael O'Brien, though sadly, this time not for the best of reasons. We'll take a closer look at what's behind the latest reports. And finally, we look ahead to what many are calling the most important day of the year for our community. Tomorrow, outside the Royal Courts of Justice, campaigners, families, and supporters will gather to mark International Falsely Accused Day. A powerful event dedicated to raising awareness, standing together, and demanding change. Stay tuned, as we bring you the stories, the voices, and the truth behind the headlines.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. As mentioned in our opening clip, on the 11th of August 2025, the Criminal Cases Review Commission referred Clive Freeman's case back to the Court of Appeal. The question remains, after more than 3 decades behind bars, will Clive Freeman at last be able to live up to his name and truly clear it? Let's uncover how the case unfolded, why it has remained controversial for decades, and why fresh evidence could finally clear his name. But before doing so, just a quick reminder to subscribe and support our mission to humanise the criminal justice system. Thank you. It was 1988. The body of Alexander Hardy, a homeless man, was discovered in a flat in Chiltern Grove, London. His remains were partially burned. That flat belonged to none other than Clive Freeman. From the very beginning, suspicion fell on him. The prosecution's case was built almost entirely on forensic testimony. Pathologist Dr. Richard Shepherd told the jury that Hardy had been suffocated before the fire was set, a method known as burking, compressing the chest until the victim cannot breathe. The prosecution argued that Freeman had killed Hardy and then started the fire as part of an insurance fraud plot. The jury agreed. In 1989, Freeman was convicted of murder, sentenced to life imprisonment with a minimum of 15 years, alongside a concurrent 5-year sentence for arson. But as the years passed, doubts began to grow. There was no eyewitness, no confession, no direct physical evidence linking Freeman to the act of suffocation. What the case had was a single expert opinion, an interpretation of forensic pathology. Freeman maintained his innocence from day one. Yet in prison, like many others in his position, he faced an impossible dilemma. To be considered for parole, prisoners are often expected to accept guilt. For Freeman, that meant admitting to a crime he swore he did not commit. So he stayed in prison, year after year, decade after decade. By the time he reached his 80s, he had spent nearly 37 years behind bars, making him one of Britain's longest-serving prisoners, still protesting innocence. But Clive Freeman didn't give up. Over the years, he applied to the Criminal Cases Review Commission, not once, not twice, but 6 times. Each application argued that his conviction was unsafe, that the forensic evidence was flawed, and that new expert opinions should be heard. For decades, the answer was always the same: no referral. But then, in August 2025, everything changed. The CCRC announced it was sending Freeman's case back to the Court of Appeal. Why? Because a new wave of pathology experts had fundamentally undermined the prosecution's case. Modern forensic science has cast serious doubt on the original testimony given in 1989. Multiple experts now say that Dr. Shepherd's conclusion that Hardy was suffocated before the fire was unsafe. Put simply, the very foundation of the conviction no longer holds. The CCRC stated there is a real possibility the Court of Appeal will quash the convictions for both the murder and arson, because if the murder conviction is unsafe, then the arson, allegedly committed to cover up the crime, must also fall. Freeman is now an elderly man in poor health, battling advanced prostate cancer. The stakes could not be higher. But this is about more than just one man. His case highlights deep flaws in the criminal justice system, the dangers of over-reliance on a single expert witness, the coercive pressure on prisoners to admit guilt just to be released, and the years it can take for wrongful convictions to even be reconsidered. We can safely argue that if Freeman's conviction is quashed, it will not only free him, it will also send a message about the urgent need for reform. Calls for change in miscarriages of justice are coming from every corner. In an article released by the BBC on the 3rd of September 2025, Peter Sullivan's lawyers argued the jury had been misled by unreliable bite mark evidence and a confession taken during vulnerable police interviews without legal advice. They say the court's refusal to admit those concerns as fresh evidence shows how rigid the system remains. We hope these series of cases will persuade the government to take on board the Law Commission's suggestions on appeal reform and the shift that is needed to create a more accessible appeal process, giving courts greater flexibility to admit fresh evidence. Let's now turn to Michael O'Brien, who has been our guest on several occasions. As we narrated in this video, Michael O'Brien was jailed for the 1987 murder of newsagent Philip Saunders, but his conviction was later quashed due to police misconduct. Upon release, he received £650,000 in compensation. However, £37,000 was deducted to cover expenses he would have incurred for living costs if he had not been imprisoned. The long-standing deduction was finally ruled unfair and abolished in August 2023 under Alex Chalk. In this video, we followed Michael O'Brien and Paul Blackburn, who spent 25 years wrongfully imprisoned as they took the government to the High Court to challenge its refusal to apply the new policy retrospectively. But on the 10th of August 2025, their judicial review was rejected. The judge ruled that reopening past compensation awards is not irrational, despite the government changing the policy in 2023 to stop deducting living costs for new claims. Michael has vowed to continue the fight, petitioning MPs and raising public awareness. More than 58,000 people have signed a petition calling for the retrospective repayment of deductions in cases like his. He says the issue is about ensuring that every person who is wrongly convicted is not penalised for a time they should never have spent in prison. Michael O'Brien's fight underscores the ongoing debate over compensation for wrongful imprisonment and the constraints of government policy in addressing historic injustices. The issue has grown even more pressing given the new hurdle introduced in 2014 requiring victims of wrongful convictions to prove their innocence beyond reasonable doubt before being eligible for compensation. In this video, we have highlighted this problem and reaffirm our support for Appeal's campaign to abolish this unfair system. We advocate for automatic compensation once a conviction is overturned, an approach that goes beyond the current proposals put forward by the Law Commission. To close, we warmly invite you to join the International Falsely Accused Day, or IFAD, with a peaceful demonstration outside the Royal Courts of Justice on the 9th of September from 2 to 4 p.m. Observed globally every year on this date, IFAD shines a light on the devastating impact of false allegations and stands in solidarity with those wrongly accused. This year's event will feature several speakers sharing powerful testimonies and insights. We want to see as many of you as possible. Don't be part of the silence. Stand with us, raise your voice, and help demand justice and recognition for the falsely accused. Together, we can ensure that no one suffers in silence and that every wrongful conviction is seen and that the world hears the voices of those who were denied their freedom. Join us and be part of the movement for truth, courage and justice. This concludes our news today. Join us again as we sit and rise in this unique trial.